and where it sort of fits in the whole legal spectrum.
Right. Well, I call it legal thinking made visible, and it's really the formulation and preparation of all kinds of documents, whether it be a lease, a will, or a contract. And it sets out the ground rules between the parties. Now, where it fits into the legal spectrum, I think law probably falls into two categories. You have the pathology of the law, which is the settlement and adjudication of disputes. And then, of course, you have the other sector, which is really the programming or planning of humans' affairs. And that is where drafting comes in. Now, I think drafting comes into all areas in that second sector, because you obviously have to, whether you're drafting a preference share condition or a will or a separation agreement, you're involved right in drafting. And therefore, it plays quite a large part in the legal spectrum.
What about the whole process? Where do you actually begin? Is it someone comes into the office, they have a problem that they need a document, and where does it go from there?
Well, the very first thing is you have to, as we all know, you sit down with the client, and then you start off, and this is called the stage of establishing what the client wants. And it's probably, well, it's one of the most important stages. Unless you elicit all the information, then inevitably, when you're doing the document itself, you'll come across some substantive concept that you forgot to get from him. And an example of that might be where you're taking instructions on a will, and if the client is dead and his wife is dead, he'll want a gift over to his children. Well, should it be divided on a capital distribution among his children, or should it descend to the children of the children if one of the client's children is deceased? And of course, that's a stirpital distribution. But I myself find in that particular aspect is one that I often overlook. I write quickly down gift over to children, and then I have to call the client back on the telephone and say, I'm sorry, I forgot to get this little piece of information. But you have to be extremely thorough and note it as you go along. Now, of course, some documents that are in printed forms, like mortgages, obviously a minimum of information is required: the parties, occupations, and interest rate, privileges in the mortgage, and that's about all. But where you're starting on something that it has to be specially drafted, or if you're preparing a precedent for the office, then you must get an enormous amount of information, probably more than you really need, but you have to fit it together. And I don't know of any way of extracting this information, any automatic way. Some have suggested maybe sending out a list, possibly, but he likes to see you face to face. He likes to talk about all the eventualities, and he mixes them up, and what comes out is a very turgid, almost mess. But you have to slowly sift it out, and then copy these down. Now, I think probably one of the neatest ways to make a little précis or note of what that particular substantive concept was. In my example, stirpital distribution, the two words would summarize what the client wanted. Then move on to the next concept and so forth.
Do draftsmen have a bedside manner, or does the relationship differ with various clients? And
Oh, I think so. I think some lawyers have an absolute talent for getting at the maximum of information. For instance, in a separation agreement, supposing you're drawing it up for a wife, well, she may feel a little more rapport with a particular lawyer and pour out all kinds of circumstances that just give him an ideal picture of what he has to provide for her. Others, well, you can feel a barrier there, and they just won't give you all the circumstances, and sometimes they don't tell you a very crucial thing that might come out on a cross-examination.
How do you approach people? You're asking them to confide the whole ball of wax in a matter of an hour, say. What is your approach to them to get them to talk and to get them to give you the information you need? Do you
well, if I can take that
or?
example of the separation agreement, I've started to get a little more subtle, I think, there anyway. I found out that the first thing they would ask me is, what's in a separation agreement? Or do I have to have one? Well, I think they're both legitimate questions. And with moving on to what's in a separation agreement, I decided to prepare a short list, and I have a list on 2 pages, and I say, while I'm just getting out this folder and putting your name down and so forth, just would you mind just going over the list? These are the usual contents of the agreement. And I now have one that's blanked off and can actually give them a genuine idea of what it looks like. And I find this helpful because without the visualization of it, some of them are still wondering what it's about, even though you've told them some of the concepts. There are other ways, and in a will, I think they can relate to the family situation very quickly. You just have to quiz them on the order of deaths and just what they really want to do. And it varies with the type of document. But I think just like yourself as interviewer, there's an expertise in asking questions, drawing out information, and I think this improves with a lawyer's experience. But I don't think there's any defined or automatic recipe for it. Although you should have in mind at all times, of course, the document that you're trying to prepare. And in some cases, believe it or not, if it's an unusually, I was asked to draft a hypothecation agreement recently, which meant just putting up shares as security for maintenance payments to a wife under a separation agreement. In other words, you put up the shares as security. If the husband defaults, some of the shares are sold off, you know, and she can have the proceeds. Now, I must admit, in getting information for that, I wasn't focusing on the agreement because I haven't done that many of that particular type of agreement. So I had to, in this case, I think I probably got less information than I should. Sometimes I get more. So I really had to go back and do that one over again.
What about the ethics involved? What do you actually owe the client? I'm thinking in terms of preparing some document that may at some point get them into trouble if there's an error in it. In other words, when you prepare it, you must always be thinking that eventually litigation could result. And how would this document stand up under pressure in court and under attack? Right. So could you ever be liable if you made a mistake and someone wound up in court?
Yes. There's an American case on that, and but the extent of liability and is not known. The frequency of cases is very little. Offhand, I can't think of one in this jurisdiction, apart from a solicitor's negligence for not carrying out a particular procedure, but I don't call that a drafting defect.
Are there any other forms of ethics that strictly apply to this that don't apply to others?
But in the ethics, I think that the ethics, you have a choice, not a choice, but you're caught between accuracy and precision. The client's wishes are what you should follow, and that's really, if you take his wishes and translate it into the document, then you have been accurate.
What about the leeway, though, between, if you define accuracy as a proper interpretation to the letter of the client's wishes, then what is the gap necessarily between that and legality in the strict sense that a court would look at it?
Well, if you wanted to carry you're talking about precision, which is something else. That means to be the ultimate in legal precision. And I think
but you have to marry the two at some point.
You have to, because you have to cut it off at some point. I've had a client say to me, now, don't worry about the renewal clause in the mortgage, we'll say, or lease is even better. Don't worry about that, because I know he's a bit touchy about that. We'll deal with that when it comes. But if I say, oh, no, I want to protect you against all possible circumstances, we don't want to see this rent getting out of hand in the renewal term. If I do that, I'm not really being honest with my client. Mind you, I can suggest that, and I always should. There's an obligation on the lawyer to do that.
What if what he's asking is not legal, or is shadily legal? What is your responsibility
Well,
there?
you have to deny it, whatever it is, and it may be, sometimes it's not all that clear. He may want to say, look, I don't want anybody challenging this will, and I want you to write what they call an ad terrorem clause. The Americans call it a no contest clause in a will. Now, if he wants me to put in that sort of thing, the effect, up to a point, the courts will accept it. But if they deny a beneficiary complete access to the courts, they usually throw it out. Now, it's a little bit murky. So there, I'd probably take the client's wishes if he insisted on it. I'd just point out my own legal thoughts on them. But if he wanted something completely illegal, we'd just have to turn it down, because we'd be in trouble with the normal code of ethics of the Law Society. But usually I find if a client is trying to do something of that nature, there's probably a legal avenue that he can do it by that may not quite conform with his wishes, but you have to explore this a little further.
So you're offering him
with
the
him.
alternatives.
I think one of the things that lawyers get into, and I've never solved this, is where a lending company does not want a second mortgage on title, and yet a day after assuming all the advances are made under the first mortgage, second, third, fourth, and fifth mortgage could be put on, and some will postpone putting on a second mortgage. And I've never really convinced myself that that's ethical or not. I'd rather think it is unethical, and yet how can clients get houses? You get into areas which are just on the borderline, and in any area of law, I think you'll get this. But really, the standard answer to that, if you recognize it as illegal, you'll just harm your practice. It'd be far better to not put that in your draft, whatever it is.
Now, we've talked about the client's wishes and the need for precision in drafting the document. If it does get to the point where litigation results, what is the role of the court? What is their discretion in throwing it out or upholding it, or what do they have to...
Yes, the court's role in this, first of all, when you're drafting at all times, you should consider the draft as something that might be read by a judge at some time. Now, I know you get into the communication process here. Who are you really communicating with? Well, first of all, I guess your client, initially yourself. If you can't satisfy yourself, you won't satisfy someone else. Then you have to think of the parties that might read it, the opposing lawyer, could be an opposing client, and then the judiciary, if it goes to court. I think my prime example of that is that in a separation agreement where lawyers will, each lawyer will see his own client sign it, and a clause will be put in saying that each party has been separately represented and has had independent legal advice. Well, the only reason for putting that in is it's just aimed at the judiciary, because if they see that, they're not as likely to have said it. In fact, they probably won't have said it at all. But the judiciary have a much stronger role, though. They have a supervisory or secondary role. This seems, conveyancers have always been very innovative, and lawyers are always dreaming up new documents, new schemes. I mentioned this hypothecation agreement, but maybe more common to some, but I'm always coming across something that I haven't run across in a previous year. Now, sky leases at one time, I had to draft something for a lease that was going up over, a building that was going up for over property that was, had a ground lease on it. Well, we got into a discussion of sky leases, and I hadn't run across that before, but then this is getting very common now. And condominium conveyancing, these are all innovative. You don't know how the courts are going to look at it, though, but I think if you observe most of the written rules of drafting, and your meaning comes out, I think you'll stand a pretty fair chance of success. It used to be a few years back, if anyone got a check after having injuries in an automobile accident, and a settlement was made, that they'd have a release form right in the back of the check. Maybe that check was given just for not necessarily personal injuries, but say property damage, and you'd hate to release your rights for the personal injuries, and yet that's what it had right on the back of the check. Now, I understand there was one case that threw that out. Therefore, the courts in that instance had a supervisory role, and to, I suppose, discipline society, that this was just not cricket. On the other hand, they've allowed certain things that one wouldn't have thought, where a person sets up a trust and a will, then, and the will perhaps has the assets being transferred to the trust on death. Sometimes the trust is amended after the date of making of the will. And now this is apparently all right. But at one time they thought, well, these documents were part of the legal environment and they're prepared at the same time. How can you amend one without making the other one somewhat invalid? So it's because they mesh together. And that's just an example how the courts will step in and either permit it, as in the case of the amendment to the trust, or deny it, as in the case of the endorsement on the check.
Are there any real pitfalls that that are common to all documents that you should be aware of, or how does it sort of evolve that you start to come up with the right words in the right order?
Here again, that's a very delicate point, and it's almost subjective, but there are some objective criterions I think you can use. I would say that I think one of the biggest difficulties when a person sets out to draft, As they go along, since words and thoughts are intertwined, then they start to think of an exception. And as one French-Canadian, who's now a judge of the Supreme Court of Canada, he said, immediately you write the word provided that, and then you go on, and further provided that, and you end up with 4 patchwork clauses on top of the main clause. And to me, that's one of the commonest diseases of documents. The organization, of course, is supreme. You have to sort it out into the classes, figure out the principle that you have to use. And most documents will have a chronological sequence, or moving from general to particular. With statutes, it's much, much more complicated. I think if you ask anyone to draft the Condominium Act, any lawyer in private practice, he'd just throw up his hands. Or the Business Corporations Act, it would probably take him half a lifetime. But these are acts that are turned out by legislative draftsmen in short intervals. And it's really hard to organize your thought, but the organization of any given document, I think, is supreme. And some of the basic pitfalls are wordiness to the extreme and using too many couplets and trinities. Couplets like each and every, that seems to appear in all documents I look at. Right, title, and interest, nominate, constitute, and appoint, give, devise, and bequeath, sign, published, and declared. These are all trinities that could be cut down to about 1 word. And I think that if that were observed alone, those few points I've mentioned, that would help clarify a good many documents, just cutting out the provisos and slimming down the language.
When you get to write this thing, you're taking something that may have been quite a personal thing to begin with, someone's immediate wishes about their own particular situation, and you have to turn that into something that is widely acceptable and, of course, strictly legal. How much is there in interpretation that you're allowed? How much leeway do you have for your own style of writing and of expressing yourself?
Here again, that's another difficult point, and it's hardly ever been analyzed, but as you know, there are different writing styles. None of us need to be reminded of that. All authors have their own style. Whether they like it or not, it's part of the product of their own personality. And this will come out, for example, in judgments that a court makes, where you can see a judge's bias, his outlook, and his capacities at the same time. No one would doubt, for example, that Mr. Justice Burl-Alaskan has a fantastic legal capacity. His erudition is just unbelievable. But it's hard to say whether there is any personal drafting style. Legal drafting is probably related closer to mathematics. And I probably could answer that best by saying that the Office of the Legislative Counsel and the Department of the Attorney General all have a uniform approach. I think it would be very difficult to see if there is any difference between Alcombrack's style. He's a legislative counsel, the senior legislative counsel, I believe now, and my friend Art Stone. I don't think you'd find much to choose between them. They have the same sort of pattern. Now, whether they came up with one particular concept, supposing like dividends in the Business Corporations Act, whether they put that in the middle of the act or 2/3 away along, both might vary. But in the actual structuring, the design of the act, and the type of phrasing, they would be similar. They'd be observing, in other words, a set of rules that, to my knowledge, has not really been laid down in print yet, except for one attempt by the Commissioners on Uniformity of Legislation back in 1947.
One of the big problems then obviously is semantics, just what words mean. Mm-hmm. And it would seem to me that there are many words that have a definition in legal terms, such as instrument, closure, things like this, that also mean something else when you're talking about them just in terms of communication and pure writing. How can you express yourself throughout these documents without changing a word and therefore changing the meaning of the thing? How do you avoid these semantic traps?
Well, first I'll acknowledge the difficulty. There are a lot of words. An instrument, by the way, I think is one that should be dropped. I think one, Mr. Weinberg, in his book on corporation precedents, has finally dropped that. He said he's going to restrict himself to the word document from now on, because that can obviously refer to medical and dental instruments, and there is a possibility of it getting confused. And it's not all that clear to the layman. I've thought of others like action. We talk about action, which is a short for court action or court proceeding. And this tends to confuse the layman as well. Or another one is file an appearance. An appearance happens to be a form, but most laymen think they have to show themselves at, say, the registrar's office of the Supreme Court. I mean, this is the impression it gives to them. How to avoid it? I don't think that there's any real way other than eliminating a word that has a multiple meaning, but sometimes you can't use any other word. If so, it's limited by its word environment, and you should make sure that there's no semantic ambiguity arising from it so that there's two prongs of meanings, or three for that matter. The best way, I think, if there's any really going to be really any difficulty in that, is to, at the beginning of the document, set out a clear definition, and then every time it's used, it will have that contained meaning. The only problem there is where, I remember, I think in one instance, example given where one used the word wheat to mean rye or something like that, and eventually he used it in the other sense later on in the documents and compounded confusion.
What about the question of colloquialisms and things that have crept into the language that, and also legal words, legal phrases that, do you avoid them, or how do you come to grips with having to use them when they arise?
Colloquialisms, I don't think colloquialisms should not be used in a document, but a good draftsman has to be aware of the language of the community to which he belongs. He just has to have that on tap, because his client will speak colloquially to him, and he must be aware of the subtle shades of meaning at all times. But I wouldn't say you should ever put them in a document, or for that matter, you shouldn't put them in legal correspondence. Legal terms, of course, are not colloquialisms, but you're talking about special types of phrasing on the document, and there are some ways a doctor has to use, you know, instead of saying someone is dying, he'll say it's a terminal case, but all the medical profession know what he means by that, and it's probably an easy abbreviation. Now, they could improve. For instance, they say contusion when they mean a bruise. But there are some cases where you just can't, in medicine as in law, use any other word. Now, the words in law that probably crop up the most often in my field, in wills, is per stirpes, meaning through the stocks in Latin, or a stirpital distribution that flows down through the family stocks. And to put that in ordinary wording would take, I'd say, probably about a half letter-sized page. And someone did make the attempt in Australia, and believe me, it sounded terribly confusing. I wish he had left it at per stirpes. Any other words don't occur to me right off the bat, but some, I think some like pari passu, like shares ranking pari passu with another set of shares, these meaning ranking equally, I think that sort of thing could be changed. Or sometimes you'll find in a statute, as in a document, the words mutatis mutandis, which simply means with appropriate variations. Well, the only thing is, why don't they say so?
So really what you're saying is that where the Latin phrase or the legal phrase says it all, where it would take half a page, you use that, and if you can say it in English clearly and in a short form, then do it that way.
You said it clearer than I could.
Is there any kind of appreciation of literature or literary background or grammatical training that you need prior to being able to do this properly?
No, I would say not. You don't need a deep knowledge of grammar at all. As a matter of fact, in some cases it might be a hindrance. One of the best-known draftsmen, legislative draftsmen, can't identify some of the parts of speech, and he's not worried about it. He has an international reputation anyway. But he likes to, the facility in welding things together, and the fluency of doing that. It's not, it won't be helped by grammar. Some of those rules are quite artificial, and drafting violates a lot of the rules. And I think if you move into the literature realm, it's much more apparent, because in literature you're used to elegant variation that Fowler talks about. We all know if things get monotonous, and in your communication, I think both in TV commercials and in giving an address to a jury. I think John Robinette's a past master of this. He can say the same thing about 3 times and make it sound like something new each time. But
is it really possible to do that in a legal document?
No, you can't. That's my point. If you say a house and lot, you can't call it lands and premises, then call it a land. Or you can't refer to a car and then call it a motor vehicle, or then a van or something like that. You're changing your language without changing your meaning. And it's just like the fabric in a suit or material. Keep the same thing throughout, and then everyone knows and can identify it. But if you start altering that, then you might just have it put in a different word environment. And then a new meaning will arise that might conflict with the meaning you intended. And this is just a no-no for drafting.
What about the use of computers or new technology and people specializing in these kind of things? Are there trends that are becoming evident?
Oh yes, there's a lot of research work, and I confess this is one area I'm not up on as much as I'd like to be, but I have done some reading in it, and I've tried some exercises in it. Some of the life insurance companies in the States found that there are ambiguities in their insurance policies, and they used a device called symbolic logic. Now, this had been promoted by a professor named Professor Lehman of Yale. And it's a workable device. It looks odd at first. It looks like a bit of algebra thrown in. He has concepts like co-implication and this sort of thing that a normal person never learned at all in school in dealing with grammar. But out of it, you develop a type of formula which can state whether, if X occurs, Y consequences will follow, but does only Y consequences follow? If so, then you have a double line between the X and the Y. And if only Y, but maybe Z and some other consequences may happen, then you just have the single line. This would be like a pharmacist's notation for a doctor that you can't read, but you know what the meaning is. This is one type. Another type is the Boolean algebra, which is the two-valued algebra. And this is used for computer technology. And some analysis has been done. The only thing is you have to eliminate ambiguities because the circuitry apparently demands this for computer work. And this algebra apparently can be learned by a high school senior in a very short space of time.
So really the same logic that applies to programming a computer, i.e. giving it the strict information, nothing ambiguous,
Yeah,
applies
right.
to drafting.
Mm-hmm. In fact, it has been used to analyze some drafting ambiguity. I think has been located in the Nuclear Test Ban Treaty, where I think the wording equally permits an explosion as banning it. One is equally coextensive with the other. But whether your point is the trend, whether it apply to the future, I just can't imagine other lawyers using it in their daily practice yet. So much of daily practice is involved with forms that are already drafted, and hopefully the outdated ones now will be redrafted and brought up to date. And then there's a much smaller segment of tailor-made documents. But I do hope that that alone might help to clear up a lot of difficulties. But the computer technology, I think, might be interesting for large documents, treaties, this sort of thing, tax conventions, perhaps.
What about specialization? Is this now something that's emerging as something that someone might tend to do with their whole legal life, or is it still just a part?
From the people I've talked to, they, including some of them in the major law firms in Toronto, they think this will come about. Matter of fact, one firm, I think everyone would know, the person in that firm said that what they wanted more than anybody else in that firm was someone who would know the meaning of every word that was put into a document, so that every word would pay its own passage and they'd just know exactly what was in it. And there is in Chicago, for example, there are people that draft nothing but leases, long-term leases, 99-year leases, for which large buildings are erected, you know. But I doubt that right away you would see much of the specialization. Quite frequently in a firm you'll find a person that has a liking for it and that will draft a lot of the important documents. And I happen to be that person in my firm. If there's an unusual document, I get it to draft.
Well, how would you characterize then the challenge of this particular field? Because I know that it would be frightening to a lot of people to get involved in the semantic battle, and the fact that it might be very inaccurate at the end, and you're never sure of what you're coming up with. What's the challenge to you?
Lawyers do it all the time anyway. They're all engaged in drafting, because even if a person brings in an agreement of purchase and sale, he will immediately change, perhaps, especially if he's acting for the vendor. He'll make sure that the commission clause at the bottom states that commission will be paid only on completion of the sale, and not just for the agent having procured the offer, as the wording states. So he's involved even in drafting or changing printed forms. And everyone is involved in that, but your point is whether one person would enlarge that function and serve that way. I think that will come because we have existed with legislative draftsmen for about a century, and these are pure specialists of a very high order, and they can draft a statute in an incredibly short space of time that applies over the whole province and sometimes lasts for years unchanged, as much as 50 years, without even one word being altered.
Would it not also mean, too, that you could cross lines in terms of the fields of law, the various aspects of law?
Oh, this is something Jim McDonald of the Law Society asked me one time. That's why he had me doing pleadings, which is not my area. But I did an analysis of that. My thesis is that, like a counsel, a litigation counsel, you can be supplied with experts in a particular field, and you can, using that think stage one of establishing what the client wants, you can draw from them the necessary information. You can use them a little like expert witnesses, if you like, and then you can draft it, because this is what the legislative draftsmen have done all the time. They have different government departments. One time they'll be drafting a revenue statute, the next will be a Pesticides Act for the Department of Health, and it goes on and on. They're just depending on, or for instance, some environmental legislation dealing with lands and forests. And they're used to switching their minds around, but they get the experts from those departments to advise them. And I think in private practice, you can have the same thing happen. You can have a person probably calling in another to say, well, this is an area in which I am not, we'll say for an inter vivos trust. Not all that many lawyers have drafted living trusts. And he knows that a client of his who wants to settle a lot of money, you know, it could be up to $500,000 or something on grandchildren, for example. He wants it drafted correctly without having to apply for a variation of that trust under the Variation of Trusts Act. I could see that would be a situation where he might want to go to someone that is a known draftsman to do that. But I wouldn't say it now that that's so, because lawyers are a little reluctant to refer clients to other lawyers. Sometimes you do it with litigation counsel, and it will come, and maybe there will be drafting counsel. But I think that's probably a long way off.
So really, right now, this is something that every lawyer should be dealing with as the basis of his
Well, he does deal with
approach.
it anyway, whether he knows it or not. He's constantly drafting this. As I mentioned, the second sector of law is this programming of human affairs. And no matter what he touches, he has to reduce the agreement to some form, something similar to our Vietnam ceasefire agreement. You've got to get it down in writing of what the parties, just to preserve it as a matter of record, that's all. That's not the highest form of communication. As a matter of fact, I think as far as that goes, it's one of the lowest forms, because it lacks all the incidental supports and intonation as we are talking here. We probably can communicate easier than if I try to write it out. The language becomes a bit stiffer, and I have to make it more explicit because I can't make gestures or raise or lower my voice and so forth. So it's not really a very effective method in the total spectrum of communication. Now, all of this, of course, won't affect lawyers, I don't think, over age 40. I think they're in their own particular rut of drafting, and they've been like this for some time. But I think the law students are more conscious of it, and they're the ones that will probably change our method of drafting in the future. And the thing that you mentioned, computer technology, I think will force it to be changed. Where they just won't put up with it. The same way that the King James Version of the Bible was revised into the New English version. That's about all I'm trying to do, is make a New English version out of documents.